Good morning. My name is Doreen Hartwell, and I am an attorney in Las Vegas, Nevada. And we're looking forward to hearing your testimony today.
Good morning. My name is Steve Jewett. I'm a county court judge in the 9th Judicial Circuit of Florida, which is in Orlando, Orange County.
And good morning from Oregon, where it is morning. I am Erin Lageson, and I am the presiding judge of Department 3 of the Oregon Court of Appeals, which is Oregon's intermediate appellate court. Looking forward to hearing you this morning.
And would you like to introduce yourselves?
Yes. Hi, we're Unified from Maine South High School. Our esteemed coaches are Andrew Tranquil and Kevin C. Hansen. I'm Anthony Coyle.
I'm Jack Koziars.
I'm Catherine Cernell.
And I'm Amelie Lascaris. Thank you for having us today.
Great, thank you. And so the question today is question 2, and it states, quote, "A Bill of Rights is what the people are entitled to against every government on earth, general or particular, and what no just government should refuse or rest on an inference," end of quote. Do you agree or disagree with Thomas Jefferson? Also, what are the advantages and disadvantages of a national Bill of Rights as compared to state bills of right? And then finally, what are the differences between positive and negative rights, and which are more important to the preservation of liberty? You may begin.
As Justice Hugo Black once said, "I cannot agree with those who think of the Bill of Rights as an 18th century straitjacket, unsuited for this age. The evils it guards against are not only old, they are with us today."
In this quote, Justice Black argues that the Bill of Rights is necessary to secure an individual's liberty and protect them against government. We agree with the sentiments by Justice Black and Thomas Jefferson that everyone is entitled to fundamental rights through a Bill of Rights.
It is critical to look at the origins of the Bill of Rights. Britain's Magna Carta established the principle that everyone is subject to the law, even the king. It guaranteed the right of independence, to justice, and most importantly, the due process of law.
The Constitution was influenced by these British documents, but after gaining independence, it was crucial to create a document best suited to the US federal government. The Federalists want to limit the people's power and establish the principle that everyone is subject to the law.
However, in an old Whig 4, anti-federalists argue that without such a Bill of Rights firmly securing the privileges of the subject, the government is always in danger of degenerating into tyranny.
Today, we see that the anti-federalists were correct to bar the government from infringing on people's rights, and has been a crucial part in maintaining and establishing people's individual liberties.
In the context of United States common law, amendments, specifically the Bill of Rights, are critical to protect rights that are being infringed on by state or federal laws. In Tinker v. Des Moines, the Supreme Court cited the First Amendment's freedom of speech to allow students to protest US intervention in Vietnam.
This limit on government is crucial if we expect freedom in criticizing government actions. In addition, the Supreme Court used the 9th and 14th Amendments in Griswold v. Connecticut to protect the rights to marital privacy, striking down previous state legislation.
As Justice Kagan states, the Supreme Court has the responsibility of ensuring that our government never oversteps its proper bounds. To fulfill this function, it is critical that the Supreme Court is equipped with the Bill of Rights and its subsequent amendments.
State constitutions provide a greater detailed view that addresses topics unique to the states.
In turn, states are allowed to create rights not constitutional in nature, such as education and privacy rights present in the California Bill of Rights. These rights focus more on limiting rather than granting power, since its general authority has already been established, often creating much longer documents.
As Hamilton stated, the security of liberty, whatever fine declarations may be inserted in any constitution respecting it, must altogether depend on public opinion. And here, after all, must we seek for the only solid basis of all our rights.
The National Bill of Rights secures our fundamental rights and protects individuals against governmental encroachments from the state and national government. Since selective incorporation, the country is united through a national understanding of liberties that protects citizens from state and national abuses.
Negative rights limit governmental power, while positive rights grant rights to individuals. The Bill of Rights was constructed to put restrictions on the federal government through negative rights, which is seen through the First Amendment.
On the other hand, the 9th Amendment grants positive rights not explicitly stated in the Constitution. By nature, positive rights are more important to the preservation of liberty because they pertain to natural right philosophies.
Negative rights have failed their duties, such as Jim Crow laws, which circumvented the 15th Amendment. Negative rights were critical at the time of the Constitution's creation to prevent an overbearing government.
However, in the modern era, we have seen a need for positive rights through topics such as abortion and same-sex marriage. In general, positive rights hold more power to personal freedom and can be used with greater success to protect individual rights.
As Franklin Roosevelt once said, we will not, under any threat or in face of any danger, surrender the guarantees of liberty that our forefathers framed for us in our Bill of Rights.
The ideas behind this fundamental document are the basis for our democracy. An efficient Bill of Rights on the state and federal level is key to ensure that the natural rights we enjoy as Americans are protected. Thank you. We are not open for questions.
Okay, thank you. What limits, if any, should be placed on rights that are listed in the Bill of Rights? In other words, they're there, but what limits should there be placed on, if any?
Well, in case of limiting our Bill of Rights, we are not in favor of, I guess, many limits on these rights. We are more in favor of more positive rights because we believe that negative rights go towards more of just kind of what we needed before in kind of preventing that overbearing government, whereas now we need rights for the people.
And as we can see, there are a few limits on many critical rights, such as in our First Amendment, our freedom of speech. The Brandenburg test requires that to limit speech, you need to have it needs to cause an imminent threat and a possible danger to limit that that First Amendment privilege of freedom of speech, which is quite hard to. It's very, very narrow.
In addition, in Schenck v. US, we see that the US is allowed to prohibit speech that poses a clear and present danger to society. So there are a few restrictions be able to put on the First Amendment, but not too many.
Okay.
Aaron?
Sure. The Supreme Court has recognized a number of individual rights under the doctrine of substantive due process, enforcing the 14th Amendment. What are some of those rights? And in your view, are they positive rights or negative rights, and why?
Well, one of these rights is the right to an education, as found in Brown v. Board of Education. And this right is, I guess, more of a positive right for all children or all people to be able to go to school and receive their education.
And building off of my colleague, the right to privacy was also found in Griswold v. Connecticut, where they argued that the penumbras cast by the Third, by the Fourth, and by the Ninth Amendments create an implied right to privacy, and this would also be seen as a positive right.
In addition, in Everson v. Board of Education, we see the 14th Amendment and the Due Process Clause incorporates the Establishment Clause into the states.
And adding on to my colleague, we can derive from the substantive due process clause specifically that we can derive a right to education because it states that everyone is under the equal protection of receiving this education, and it is stated as a positive right.
Under what circumstances, if any, would a person lose rights found in the Bill of Rights?
Well, under the circumstances of where they are not found to be, or in cases where they need to object some of their personal rights and some of their personal liberties for the greater good. And we've kind of seen this in the past with the Boston bombing, where people have given up part of their individual rights for the common good of trying to find those terrorists.
And many of the critical rights in the First Amendment fall under strict scrutiny when someone has to give up their rights. So they have to, laws that violate or that object these rights have to follow two prongs. The government has to show a clear, compelling interest, and they have to be in the least restrictive means possible. And these are rather hard to prove, almost always being lethal to the government and their statutes that they want to pass. And thus these rights are very rarely infringed upon.
And adding on to my colleague, through the Ninth Amendment, it states that all the rights not stated in the Constitution are enumerated towards the people. However, this has been seen too broad, as seen through Google and Apple's contact tracing efforts, because HIPAA is not protecting the person's right to privacy. So we lose an expectation of privacy through these efforts for the common good.
Okay. Well, you talk about some states' Bill of Rights and federal Bill of Rights. Let's say that there's the one state's Bill of Rights and a federal Bill of Rights are in conflict. whatever state, whether, I don't know if Illinois does, and in Florida we do have a state Bill of Rights, but what if they're in conflict? How does that get resolved?
Well, as we see in Article 6, Section 2, the Supremacy Clause, we see that federal Bill of Rights will take precedence over the state Bill of Rights.
In all situations, what if the state is more expansive? In other words, they grant more rights.
Well, in cases like there, we can kind of see this with the right to an education again, where states have it defined in their, many of their state constitutions define a right to an education, where it is not defined directly in the national constitution. So in cases like this, where it's more expansive, yes, you would turn towards the states in granting more of those positive rights.
Okay. Aaron?
Sure. One of the arguments against including the Bill of Rights in the national constitution was that if something wasn't written there, later courts might think you don't have that right. And currently, the U.S. Supreme Court there's a number of judges who subscribe to originalism as an interpretive philosophy, and a lot of that philosophy is if it's not written in the text of the Constitution, it's not there. Evaluate the argument. Were the opponents of the Bill of Rights onto something in light of how things have gone?
Yes, through the 10th Amendment, it states that the rights not in the Constitution are reserved for the states. So states have been incorporating rights through their state constitutions through selective incorporation. So many states have the First, Fourth, Fifth, and Sixth Amendment. However, provisions such as the requirement of indictment by a grand jury stated through the Sixth Amendment and the requirement of a jury in a civil case through the Seventh Amendment have not been incorporated through the states through selective incorporation.
And in addition to my colleague, this debate was addressed by Alexander Hamilton in Federalist 84, because the Federalist original plan was to have rights protected by legislation through Congress and not through amendment. And in order to form the Union, they believed that if we were to include a Bill of Rights, the Ninth Amendment is critical to resolve this issue, to allow some implied rights to exist should the Supreme Court find them through other statutes.
In addition, in Federalist 48, it states that Hamilton and Madison argued that the Constitution would create parchment barriers that would, in fact, limit rights instead of protecting them. And this is why they were stated as negative rights versus positive rights.
What positive rights not listed in the Bill of Rights, if any, do you think should be added?
Well, we believe that there's a couple of rights that are kind of getting infringed upon right now that are not directly written. And these are the right to privacy, your right to vote, and your right to healthcare. And we can kind of take example, the right to vote, where it's kind of being infringed upon. Take, for example, the new Georgia law being up for debate right now with their voting and restrictions on that.
And in addition to this, we've seen the role of the right to abortion change, because in Roe v. Wade, it had a stronger protection to the right to abortion. And then later in Planned Parenthood v. Casey, this positive right changed. And that's why we believe that in addition to those rights that my colleague mentioned, abortion should also be protected explicitly as a positive right.
Great. Thank you.
Got time? I didn't even see the time signal.
Well, you guys, good job. I just thought that was really well done. Your prepared remarks really covered everything. You had the historical from starting with the with the mention of the Magna Carta and just kind of walked us through. It was filled with lots of examples. Your prepared remarks completely answered the question. You covered everything that was asked. You gave your opinion that, yes, you agreed with Thomas Jefferson's sentiment. And then you went on and explained exactly why. I thought your prepared remarks were really well done. You covered it and you explained the difference between negative rights, positive rights. You even brought up natural rights with regards to the Ninth Amendment and things that the rights that are expressly enumerated in the Bill of Rights. And I thought with regard to your responses that all of your your answers really did answer, you were responsive to the questions asked. And you gave lots of evidence, good evidence in support of your positions. I thought with regard, and everyone did, everyone participated, which was great. I thought your references back to the Federalist Papers and with regards to the Ninth Amendment was great. Your identification of additional rights that weren't included in the Bill of Rights, I thought was great with regards to the Sixth Amendment and the Seventh Amendment, the right to the jury trial and a right to a speedy trial. I just thought, well done. You guys clearly did your homework and were really prepared, and you had a really good grasp of the issues. So good job.
Yeah, okay, really good, great. You know, and I'll tell you what I thought was, first of all, when the time runs out and I don't realize it's time is always a good sign. That means that it's been, you know, interesting and enjoyable. A couple of things though, you know, this is only the second time, obviously second time for you too. We just started at 1 o'clock. And so we're sort of honing our questions in. And this time we totally threw some curveballs out there. Each one of us asked a question that we hadn't even talked about. I mean, we kind of did, but they were not questions that were from the suggested questions, and you guys just pounded them out of the park. I mean, there was the substantive rights question, substantive due process question that Aaron asked, didn't even phase you. Then we were talking, and then it was fantastic. Really good job. It's clear that you understand the concepts and have studied the issue and are ready for anything that comes at you. So really, really, really good job. Appreciate it.
I echo that your participation was great. Your prepared remarks addressed the question and covered all the bases, and your command of current events, case law, founding documents is really impressive. It's clear that you've spent a lot of time learning a bunch of sources, and you were very deft at responding to some of the curveball questions. If I were going to give you any constructive criticism going forward, I would think about maybe having some more debate or discussion among your team about whether a right is a positive right or a negative right, particularly when it comes to the substantive due process rights, because I think you can make you identified them as positive rights, but I think you could also make an argument that the right to abortion, correctly understood, is a negative right where the government, the state, is limited or prohibited from passing certain laws that interfere with a woman's liberty interest in choosing. And similarly, there's, I don't think you mentioned it, but it goes to your other Unit 5 question. So the right of parental control over can be conceived of sort of a right to keep government out or a limitation on government. And I think your team, if you maybe took some different positions on that and explain, here's the aspects that make it look like a positive, here's the aspect that make it look like a negative, you could add some additional depth to your presentation going forward. But apart from that, it was fantastic and just wonderful to listen to you.
Thank you very much for all your feedback. It's much